documenting the investigation. All forensic investigations require meticulous work, and it's sometimes tedious for the examiners, but actually you have to be very careful in preparing or in processing the evidence. And when it comes to documenting the investigation, you should not miss any important part, and the documentation phase is a very critical phase in which you are expected to present the evidence through the documentation in your investigative case. The objectives of this session is to understand obtaining evidence from a service provider and describe documenting a crime scene, describe seizing evidence, and understand documenting and handling evidence, and describe forensic tools for documenting an investigation, describe report writing, and understand the role of an expert witness, and understand standard operating procedures. There are actually a number of issues in terms of documenting the investigation, and writing a detailed, comprehensive investigative report is key to successfully prosecuting a criminal. The report should be detailed enough to elaborate the important parts of the investigation where the information leads to successfully prosecution of the offenders. Someone with no technical background must be able to understand important concepts and the value of the evidence presented actually in the case. So even if a person uh, involved in the case, in the trial, whether the defense attorney or the prosecutor or the jury actually without a technical knowledge must be able to understand the important concepts in the investigation, and the concepts needs to be explained in a more easier way for people who do not have technical knowledge. Retention is another important aspect where the prosecution, or let's say the investigative part of the case actually request retention of data from the service providers. And trillions of text messages are sent annually. 85% of photographs taken in 2017 were taken with a smartphone. And with the introduction of 5G, smartphone usage will only continue to grow actually. The retention time for these communication is only a few days, which is quite a bit of a limited time for investigators to collect the information. The retention policy for communication varies from company to company. Can request that communications from a service provider relating to a suspect be retained pending the approval of a warrant or subpoena. A preservation order is typically a request to a service provider to retain the records relating to a suspect. In general, a provider of wire or electronic communication service or a remote computing service upon the request of a governmental entity shall take all necessary steps to preserve records and other evidence in its possession pending the issuance of a court order or other processes. Shall be retained for a period of 90 days, which shall be extended for an additional 90-day period upon a renewed request by the government entity. This gives law enforcement close to 6 months to obtain a signed warrant from a judge or magistrate, and 6 months usually in the first phase of the investigation, enough to help the investigator collect information about the specifics of the target being under the surveillance. Investigators must remember that they should inform the service provider, not to inform the suspect, which is the crucial element of the investigation. That such a request has been made, or else the suspect is likely to know that the information is being shared with law enforcement. An investigator is more likely to ask a judge to request that the service provider not inform the suspect that he or she is being investigated in the subpoena. Certain open source tools are available to image a hard drive, but one of the reasons for using licensed products such as Blacklight is to take advantage of comprehensive reporting feature that comes with the software. When handling evidence in documenting an investigation, the assumption must always be that the evidence will end up in the court, and the investigator must be preparing a well detailed and understandable report. Each item must thus be handled in accordance with the law. Defense attorneys will thoroughly examine the chain of custody form and try to find mistakes to render the evidence inadmissible. Mistakes can occur more with digital evidence than with other types of evidence, such as a gun or dress. Forensics examiner should always photograph and document everything found in the crime scene. Photograph the connections between the devices, which is important to reconstruct the events related with the investigation. And these can be quite complex, and photographs help the examiner back at the lab to see how devices were configured and connected. Here you are seeing an evidence list on the slide. This is the item number, date, and the manufacturer of the, for instance, hard drive and the model of it, or the computer's model, and the serial number of the laptop, or and the description of the item found during the investigation, and then the custodian who actually holds the evidence, and location of the accusation should be involved in the evidence list. This is actually very helpful to understand the evidence and its peripheral information that's related with the evidence. Standard operating procedures is highly important when you look backwards for your investigation. It's also gonna be very easy for you to actually figure out what you have done previously, as you are used to or get used to what you're doing, and test it in previous cases. And the investigation must be followed from the standard operating procedure must be followed from the crime scene to the forensics labs to the courtroom. Defense counsel often spends much of its time questioning the actions taken by investigator. Because of that, the investigation is required to follow the standard operating procedures. Publicly available best practices guides, which are shown on this slide, as well as your textbook, you can actually use these guidelines. And the investigator must carry a notebook and take copies, copious notes about any equipment they find. They also must inform first responders about what to do if they encounter digital evidence. For instance, if a computer is powered on, it should be left on. If the monitor shows activity such as instant messaging, it should be photographed first. Under no circumstances should an inexperienced officer or investigator review evidence at the crime scene. This includes actually watching a video or reviewing photos. And first responders should let the digital forensics examiner analyze the evidence in the lab. Crime scene investigators use several tools, equipments, and devices to work on collecting the evidence. That actually includes notebooks, laptops, cameras, extra batteries for camera is important, extra SD card for camera, sanitizing the USB flash drive and sanitized USB flash drives, flashlights, computer tool set, which is the crucial element of the collection of digital evidence, and write blocker is a must that because you are actually supposed to abide by the law and prevent the temperament of the evidence. And anti-static bags, stronghold bags for phones and tablets, and Faraday box, evidence tape, as well as dry bay labels, which are important parts of the investigation where the investigator needs to carry all these items. Documenting the evidence is the crucial part of the investigation. Forensic tools enable the investigators analyze evidence files and add them to a report so that the defense and jury do not need to wade through thousands of files. Also allow the investigator to add notes to a tagged evidence files, take screenshots, and record other steps taken during the examination. When handling evidence and documenting the investigation, the assumption must always be that the evidence will end up in court. Each item must therefore be handled in accordance with the law. Evidence should be legally obtained through a court order, subpoena, or search warrant, or with consent of the owner. Subpoena is a type of court order whereby a person is ordered to come to the court to testify. A court order is an order that's generally issued by a judge, and a warrant necessitates that certain requirements be met, like probable cause. These parameters change for business owners who obtain evidence from employee who is a suspect after that, and evidence has been seized after that. The investigator needs to possess and maintain a chain of custody form always. Custody form where the investigators and the people involved in the investigation actually needs to uh, write the uh, examiner information, the suspect names and case number and the page number regarding the case, and the item number that's collected as an evidence, and the information uh, related related with the manufacturer, and the model number of the item, and serial number, and the description of these types of item. And here what you are seeing is the released by the signature and date and time, and this actually help us to see the item is released by whom and received by uh, whom as well, in order for us to track the evidence delivered into different locations. Should complete a separate computer worksheet for each computer that's analyzed, which will include the name and information of the suspect or custodian, case number, date, location, and investigator, make, model, and serial number of the computer as well. Worksheet should be completed for each of the hard disk drive as well. Some systems, such as the RAID systems, have multiple hard drives. Hence, it's important to keep the worksheets properly. And also, the details of the worksheet should include the suspect's name and the custodian name as well, and case number, date, location, investigator, make, model, and serial number of the hard drive as well. Examinations. There are tools that can help you document the investigations. Computer forensics investigators and security professionals can use the network analyzer. This application is available for both iPhone and iPad from the App Store. When activated, the app can scan for Wi-Fi connections, and between these access points, they can determine the name and IP address for all connected devices, which is important for the investigator to document the scope of the network. System Status is an all-in-one app for monitoring your iPhone and iPad performance normally. But it also provides a list of running processes, which is helpful because processes could be running on a suspect or victim cell phone in a stealth mode, which you cannot easily understand it, meaning that no icon appears for the installed applications. And this is an important process to understand the whole process is running on a given iPhone or iPad. The COP app is designed to allow law enforcement officials, military, private investigators to quickly and easily create a report based on observable events for use in court for their own records or for other proceedings. LawStax FRCP is a helpful reference guide for federal rules of civil procedures to understand the necessary steps for the investigators which needs to be taken according to the law. Writing reports is a crucial element of the documentation process. The purpose of the computer forensics investigator's report is to detail findings, not to convey an opinion or convince a jury that a suspect is guilty. The report is a statement of facts, and the jury must decide on the issue of guilt. An investigator must not only state his or her findings, but also provide full details about the process of the investigation. The investigator must note the current time and date and the source of the computer where it was located. All system times for the devices being examined must be noted and compared to the investigator style. The website timeanddate.com can assist you with the date and time formats when working out time zones and can answer other important questions you may have during the investigation. Every detail in the report must technically be precise. The report also needs to be comprehensive so that someone with limited technical knowledge can understand the investigator's actions and the report of report findings. The report should not have acronyms unless they are explained earlier in the report. For example, in your report, you could write uh, creating an MD5 hash is a standard for computer forensics investigators to ensure that the copy that they are working from is unaltered from the original media seized from the suspect's computer. This kind of an reporting can help both the investigator to explain the uh, case or the examination in an easier way, and for the uh, jury and the actually defenders and many other sides in the investigation can also understand the subjects during the investigation. Graphical representation is often superior to the written word. The saying that a picture can tell 1,000 words is true. For example, a spreadsheet with a code log is far less effective than a graphic displaying a picture of the suspect with lines to contact he or she communicated. A graphical timeline of events is also superior to a simple list. And the use of maps can indicate how file metadata can place the moments of the suspect. Basic for computer forensic analysis steps include accusation and preservation, examination, analysis, and also presentation. And the forensic products that's covered in our investigation may include reports, testimony, notes, and also exhibits. Forensic reports are one of the most contentious areas, and some people say put the minimum amount in the report, and some others may say put everything in it, and maybe select key information to include. Obviously, each has some drawbacks. You will have to make choices. You will have to also defend your choices based on your investigation. A cynic would argue that the reports are the raw material for your lynching. You can only get, and they can only get you in trouble. And uh, these reports also can give the opposing counsel an advantage. While these are natural emotions, they are wrong, and a well-written report is your best friend on the stand. A report answers the question about what was the result of your examination, and it includes pertinent facts and conclusion about the case, and it doesn't report everything that you did. It will be a tremendous report that would overwhelm the readers if you include every bit of your step in your investigation. And it's also a legal document, and it has consequences, and your report provides the basis of your testimony. Structuring the report is essential to form a comprehensive analysis, to present a comprehensive analysis and the documentation of the evidence. So in a well-structured forensic report, you should have a cover page, table of contents, executive summary, biography of yours. The purpose of the investigation is definitely important. Tasking, methodology that you have gone through, and electronic media analyzed during the investigation. And obviously report findings that describes what you've done and what you have found during your investigation, and investigation details connected to the case and exhibits and conclusion, and obviously glossary, which is essential to inform the reader about the and understand the technicalities of the report. Here you can see an sample laboratory report which you can always benefit from the sample laboratory report. And there are some actually explanations in the report which you can go over at your convenience. The cover page of your report must include a report title, the author of the report, the department and organization that processed the evidence, the investigation number and the report date, and also the cover page might also include the signature and date lines for those involved in the investigation. An organized report should also include a table of contents to assist prosecuting attorneys and defense attorneys, as well as any expert witnesses who may be called upon to examine the report, which is essential part of the report to help people go through your report in an easier way. The executive summary portion of the report will provide a synopsis of the purpose of the examination and the investigator's major findings. In law enforcement, as separation of duties often occurs, particularly in larger computer forensics labs. This means that one officer works for the investigation and another officer performs the forensic analysis. Hence, the work of more than one law enforcement agent is actually included in the report, and that must be clearly outlined in the report. Your biography is important when you have a job interview or job application, but in this case, your biography actually indicates that you are qualified to examine the digital evidence and investigate the whereabouts of the digital evidence or crime. A brief biography of the investigator should be included, which highlights all relevant experience of the investigator. This section should include college degrees, certifications, and any digital forensics training classes completed. An approximate number of hours of pertinent training should also be noted. The investigator should also detail her investigative and personal experience, as an experienced investigator is more qualified to shed light on the investigation. For example, include how many years of experience working in her department. Ultimately, this section should explain why the investigator is suitable for the investigation, why the investigator has conducted an investigation and produced reliable findings related to the case. You also need to include the tasking section in your report. The tasking section sets forth who asked you to do the examination, what was their authority, and what did they ask you to do. It's in effect a restatement of your examination goals from your exam plan. It frames what you do in connection with the examination and provides the reasoning for what you did or did not do. Most people don't spend enough time and effort on this, but this tells you when you are done actually, and tasking is important to prove that you actually completed the assignment in a more complete or true manner. For example, you can use this statement on your tasking example on the on 3105 Detective John Jones from the Such Police Department delivered a 3.5-inch Seagate hard drive with serial number to me, and Detective Jones provided me with a copy of a search warrant issued by Judge Sally Dewey authorizing the search of this hard drive for information concerning the manufacture, possession, or distribution of controlled dangerous substances in violation of such statute. statue by Roger Marks. And Detective Jones provided the following summary of the case and such and so forth, and requested that an examination be conducted to identify such evidences. So you can include these types of statements in your tasking section as an example. The purpose of this investigation as a section is optional because the report writer might have already explained the reason for conducting the investigation in the executive summary. To set the tone for the report writer might want to explain the reason for the investigation and the scope of the warrant, which will either help to explain the types of computing devices and media that were examined and the areas of memory storage that were analyzed. For example, picture and media files will be important in a suspected pedophile case where emails might be particularly important in a corporate insider investigation. You may answer the following questions in the forensic questions section that identify relevant information concerning electronic media analyzed and case information, and locate all documents, files, compare file hashes of the evidence, associate files, media, computer, IP address with the investigation, and reconstruct the events activities which resulted in the formation of the investigation. In the methodology section, you need to explain the science behind the examination. It should explain the approach the forensic examiner took, which might include a rationale for the choice of software or hardware tools. The investigator may also reference standard practices for computer forensics examination that were used in the examination, and these could be lab specific. It's important to describe in detail the media examined, how the storage media related to the other media examined, and how these objects related to the suspects. So you need to prove a relationship between the media and suspects, and how the storage media related to the other media in your examination, which is also another important part of your examination. The report findings should be clear about the findings related to the nature of the investigation. It's improper to say that Doi downloaded thousands of images of children being abused. This is not a precise way of describing how the criminal events occurred. The proper way is to say that analysis performed on the hard disk drive removed from the Dell computer model and with service tag, and this computer was seized from the residence of John Doe from the such address. A total of 578,000 images of children were downloaded, and you can continue with containing precise information about the whereabouts of the evidence that's related with the case. In another examples, in your findings section, you could say in the directory a series of files which collectively constitute a website was located, and these files, when viewed in a web browser, advertise the sale of chemicals used in cocaine processing was located, and the website's metadata indicated that the site was developed by the Microsoft Office Publisher 2003, and that the creator of this website was Roger Marks. You can include such information as well to be more precise on your investigation. And in the conclusion, opinions section, and this is where the ice gets thin. The limit conclusions to what you absolutely, positively, and completely can prove within the four corners of the report, and you want to make sure that you do not make any mistake and you're sure and absolutely positive on your findings. And do not make investigative conclusions. Facts are conclusions, opinions are based in part on experience. If the answer is not absolute, it's probably an opinion. And here we see another conclusion here based on my comparison of the website files located in such directory with those located at www such website. The two sites are identical. This conclusion is based on the file name, size, mathematical signature, and the direct comparison of the individual files. Here you can also state a similar opinion in your investigation as needed. The investigation details connected to the case is not necessarily a separate section. It's important to note supporting evidence to the investigation that's not visible. This might include statements from the suspects and witnesses which might be supportive of your investigation. Placing a comprehensive glossary at the end of the report is a good feature. The defense counsel often argues that they were at a disadvantage because of the lack of resources available to their investigation compared to those available to the law enforcement. By assisting and cooperating with the defense counsel and including a glossary, footnotes, and other helpful resources, you will diminish these arguments of inequality. A good forensic examiner must take notes to elaborate the case and follow each step in their notes to make sure that he was doing the right thing, and when he goes back to his notes, or when she goes back to his notes, she or he should be able to comprehend what's done during the investigation. Notes must contain sufficient information that a skilled examiner could replicate your results and demonstrate the basis of your conclusions. They are discoverable and are made available to counsel prior to the trial. Notes are not part of the report, but if it isn't in the notes, it didn't happen. In summary, writing reports is an art, and it requires careful consideration of all the issues, technical and legal. And many edits and rewrites are often necessary to develop your report. And you need to be careful when you will have to live with what you wrote on the stand. That's the spirit of the report writing. An expert witness's task is similar to an investigator, and an expert witness can create an investigative report or review the findings of the investigative report prepared by the law enforcement, and then interpret those findings based on the specialized education, training, and knowledge of the expert. The expert is usually hired by an attorney to be an advisor. Ultimately, an attorney can call upon the expert witness to discredit or refute the report findings or to drive out the importance of the incriminating evidence highlighted in a report at trial. The role of the expert witness to educate the jury. In fact, both the prosecution and the defense counsel can hire their own experts and ask them to testify. The role of the expert witness at trial is also described in federal rules of evidence. Although an expert cannot pass judgment on a defendant, an expert can provide opinion based on the facts. The expert witness should educate the jury and break down complex concepts into meaningful information. For example, an algorithm can be explained using the metaphor of a cake recipe, with a list of steps to reach a particular outcome. Metaphors can really help with the comprehension of the jury. The expert is also there to persuade while weaving in important concepts can help with this. The expert witness is required to provide a written report as noted in Rule 26 2B, disclosure of expert testimony in the Federal Rules of Civil Procedure. The report must contain a complete statement of all opinions the witness will express and the basis and reasons for them, the facts or data considered by the witness informing them, and any exhibits that will be used to summarize or support them, the witness's qualifications, including a list of all publications offered in the previous 10 years, a list of all other cases in which during the previous 4 years the witness testified as an expert at trial or by deposition, and a statement of the compensation to be paid for the study and testimony in the case. The expert witness should ensure that her CV is up to date, and he or she would need to refresh her memory about her training, because a good defense attorney often questions experts about their trainings on forensics tools and calculates how many hours they have, and they may try to show that you are not competent enough to examine the case, and maybe defense will the defense attorney will try to refute your findings by trying to discredit your trainings and education. Thank you very much, you all, for listening to this session, and we have covered quite a bit of information in documenting the investigation. And please check your Blackboard content folder for this week, and I shared some sample files for you to be able to take as an example of your feature reports.